If you were arrested for domestic violence and the alleged victim is not on your side, then in this video, I'm going to be giving you some information that I guarantee will help you stay one step ahead of what is likely to happen. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything that you need to know to represent yourself at your restraining order hearing and have your best chance at winning. So if that is something that you need help with, either now or if you find yourself needing help with that in the future, you can get your free first class via the link in the description box below. Okay, so let's jump right in. So you got arrested, you bonded out, you have court coming up, and the alleged victim is not on your side. What you can expect next is to be served by a sheriff's deputy with a restraining order. Now, I'm not talking about the emergency protective order, the one-page piece of paper that you may have received when you initially were arrested. There is a different type of restraining order. It is called a domestic violence restraining order. See, when the police come out and they are talking to the alleged victim, many times they give them advice. They'll tell them, you might want to go down to the courthouse and get a restraining order so that he or she cannot come back here. So if the alleged victim didn't know before that they could get this restraining order, now they know. The police have told them. And oftentimes that is going to be the very next step. They go into court, they will get a restraining order the same day that prohibits you from returning to the home. And if it includes custody, which it almost always does, that's often the motivation for filing one of these domestic violence restraining orders, then they will have custody until there is actually a hearing on the restraining order. The courts are so backed up that they typically end up getting extended, sometimes for months at a time, which can be a real problem when this piece of paper, when this temporary restraining order prohibits you from living in your home, that you still, if you had to pay rent before, if you're on the lease, you still have to pay rent. If you're on the mortgage, you still have to pay the mortgage, yet you can't live there. And so now you have to figure out how to afford another place to stay. What about seeing your kids or your pets or your furniture, everything that is in the home? Well, you're also, with the exception of sometimes being able to get a few of your personal belongings accompanied by a sheriff's deputy, you're not going to have access to any of those while this temporary restraining order is in place. And this is something that it's put in place without you getting to tell your side of the story, right? So it can be completely based on lies. It can be based on accusations that are different than what is in the police report. A judge will look at what was written down, spend a few minutes on it at the most, and then basically rubber stamp it. Now you're served with this, and many of your rights are taken away. What can you do to prevent this? I'm going to give you a controversial idea here. You can file a temporary restraining order first, because here's how it works. Whoever files for the restraining order first gets custody of the kids if they ask for it, as long as they have sufficient facts in there alleging domestic violence. They also get the residence until the hearing, right? They get the pets until the hearing. If the alleged victim files a restraining order and then you file one as well, yours doesn't cancel hers out. That's not how it works. Whoever files first is the one who gets the kids and gets the house and gets everything until the hearing on the restraining order. When you file one back and you ask for custody of the kids, that is going to be ignored until the actual hearing, which again could be months down the line. Now, are there some downsides to this or potential downsides? Sure. The first one is that when you are filing a request for a restraining order, you have to write down your side of the story. So if what you're going to include in this request for a restraining order is anything about what happened the day that you are arrested, that could potentially be used against you. Now, if you are filing a request for a restraining order, are you going to, in that request, confess to any crimes? Hopefully not. I mean, what happens a lot of times when people get arrested for domestic violence and they were falsely accused is that actually they were acting in self-defense, but the cops come out and they say, you know what, we have to arrest someone. So maybe the other party attacked you. You are actually the victim and you were just defending yourself here. Now, because of this, it is advisable, if you are going to talk about that most recent incident, to contact a criminal defense attorney, right? You don't necessarily need an attorney to request a restraining order, but you want to give the defense attorney your statement so that they can take a look at it and see if this is something that they feel comfortable with you filing. Maybe you don't have a defense attorney yet. Something else that you could potentially do is you could not talk about that most recent incident that just happened, but you could talk about any prior abuse. If you were defending yourself in this situation, were there any other instances when you were also defending yourself, when the other person slapped you, when the other person, even if they were not physically violent, harassed you, demanded to look through your phone, disturbed your peace? That is another type of domestic violence for the purposes of domestic violence restraining orders. Not necessarily for criminal cases, but for domestic violence restraining orders. Maybe the other person called you 50 times when you didn't want to talk to them and you didn't answer the phone. These are all things that could potentially support a restraining order without you talking about this most recent incident in which you were arrested. Therefore, to some extent, at least in that initial paperwork that you file, you avoid making a statement about the incident for which you were arrested. You avoid potentially putting your foot in your mouth and saying something that makes it seem like maybe you used excessive force, or maybe you say something that's different than what you said to the police. You eventually do get to that restraining order hearing. When it actually does happen, well, you can be asked at that point about what happened during this most recent incident, during this arrest that you had. Now, at that point, you can plead the fifth. That doesn't necessarily look all that good, but it is a possibility. Now, the other problem here is, let's say that the other side was not planning to file a restraining order against you. And now they get your paperwork, so they decide that they are going to file a restraining order. Well, in this case, you were still first, right? So you still are the one who would have custody of the kids. You are still the one that would have the home. But now you could end up with, after the hearing, you could end up with a permanent restraining order against you. Permanent meaning up to 5 years. That could happen when maybe it wouldn't have happened otherwise. Another potential downside is that generally, and I practice criminal defense in addition to defending people in restraining order cases, typically I advise my criminal defense clients not to take any action against the alleged victim. Now, the reason why you wouldn't want to take action is because you don't want to upset them. You don't want to make them more angry with you and potentially contact the DA so that if the case does get filed, potentially it becomes worse. What if the case ends up going to trial? Now you have somebody who's even more upset because you filed a restraining order against him or her. Maybe now there's sort of a fire under them to testify against you. So that is a possibility, and that is the general criminal defense advice. But when you think about the whole situation, most criminal defense attorneys will probably tell you don't take any action, don't make any statements. I mean, that is the most conservative advice possible, but what else will you lose if you follow that advice? You have to think about, okay, is this a home that I'm on the lease for or the mortgage for? Am I okay with not seeing my children potentially for months, like not seeing them at all, no contact with them, not speaking to them, nothing, potentially for months? Is that okay with me? Now look, I'm sharing this idea with you because I've seen this happen time and time again. A client hires me for their criminal case. Things are not good with the alleged victim, and then they get slapped with a restraining order. Sometimes it takes a week, sometimes a little bit longer, but they get slapped with a restraining order. The other party files it before they get a chance to, and now all of a sudden they don't have a place to live. They cannot see their kids, and of course they can go to the restraining order hearing and defend themselves, and they can do that with or without an attorney. You can represent yourself at your restraining order hearing and win, but the problem is that in the meantime, you are potentially really suffering. So if you can stay one step ahead of everything, and before the other side gets a chance, file a restraining order against them first. And of course, you have to have a legal basis to do it. I'm not telling anyone to make anything up here, but in most of these cases, you are going to probably have enough to at least get that temporary restraining order and set the hearing date so that in the meantime, while you are waiting for the hearing to actually happen, her life will not be torn apart as it could be if the other side filed that restraining order first. I hope you found this video helpful. And again, if you do get served with a restraining order, or if you file a restraining order and you have a hearing for it, you can represent yourself at that hearing and win. It's just a matter of knowing exactly what to do. Too many people show up for the hearing, try to just litigate all the issues in the relationship and show that they are a better person or a better partner than the other, which is not what the court is looking for. It's not rocket science. You just need to know what the court is looking for and how to give it to the court, which is what I give you in the course. So if that's something you're interested in, you can get your free first class in that via the link down below. If you do have a criminal case in California or a restraining order case, feel free to give me a call. You can find the link down below. And if you did find the video helpful, please don't forget to subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.